Hello, this is the Civil Rights Section A Equality Before the Law lecture. We're hitting Prioritized Standard Government Civics number 18. Objectively, we're going to examine how the 14th Amendment's Equal Protection Clause made possible civil rights reforms. While civil liberties are concerned with protections against government actions, civil rights refers to positive actions the government should take to create equal conditions for all Americans. So it has to do with the government actively doing things to create more equal conditions. Civil rights are primarily concerned with the protection of rights for minority groups, with the 14th Amendment of 1868 and its Equal Protection Clause providing the basis for most civil rights-based legal challenges since its passage. Which brings us to a case, Scott v. Sandford of 1857. In this case, we had Dred Scott, who was born a slave. Then him and his slaveholder moved to a state where there was no slavery. And then they moved back to a state with slavery. So then he asked a question of the court, am I still a slave since I lived in a slave state? And in Scott v. Sandford of 1857, the Supreme Court declared that blacks were not citizens. So if you're curious, how did that come about? It's like, wasn't it about something else? They basically determined that, hey, that's a great question. Excellent question you're asking. But, I'm afraid you're black, and black people aren't actually citizens of the United States, and only citizens of the United States are allowed to have cases heard by the Supreme Court, so get on out of here. Which led to the 14th Amendment, overturning the Scott versus Sandford case, which stated that all people born in this country are citizens with full rights and are guaranteed equal protection of the laws, which is the Equal Protection Clause of that amendment. The Equal Protection Challenge has not been a universally accepted legal challenge by the Supreme Court, as was highlighted in the Korematsu v. United States 1944 case that questioned the constitutionality of the Japanese internment camps during World War II. In the case, Korematsu claimed that the internment camps violated equal protection of the laws, which, generally speaking, they pretty much did. The court ruled in a 6-3 margin, if you love your margins, that the government's need to protect against potential espionage, which means spying, outweighed the Japanese Americans' rights. They basically said the actions were justified during what they called circumstances of emergency and peril. Should point out, our government has actually apologized for Japanese internment on several occasions. Very recently, the Supreme Court actually reversed the Korematsu versus United States case, but it is still one of those parts of our history. While Americans have been guaranteed equal protection since the late 19th century, many groups have continued to suffer discrimination. For instance, blacks, Native Americans, Hispanics, and Asians suffer racial discrimination. Women have suffered gender discrimination, and those practicing different religions, those with disabilities, and those of non-traditional sexual orientations also suffer types of discrimination. Both legislation passed by Congress and legal precedents created by Supreme Court cases have had the power of impacting the advancement of civil rights. Congress has passed several laws that attempted to greater ensure equality among its citizens. The Civil Rights Act of 1964 prohibited discrimination in employment based on race, religion, gender, or national origin, and outlawed discrimination in public accommodations, facilities, and also schools. It also gave the Department of Justice the authority to bring lawsuits to enforce school desegregation. The Civil Rights Act of 1964 also restricted tax dollars from going to organizations that discriminated. So taking away tax money if you're not doing what you're supposed to be doing and not discriminating. And it also created the Equal Employment Opportunity Commission, or EEOC for short, to enforce fair employment policies. So if there's businesses not doing what they're supposed to be doing, this is the part of the government that will make sure they abide. Civil Rights Act of 1968, which is sometimes known as the Fair Housing Act, prohibited discrimination in the sale or rental of housing based on race, religion, or national origin. Gender was added as a protected class in 1974. Wasn't originally part of it, but in 74 it became a part. And people with disabilities and families were also added as a protected class in 1988. So this has had other groups added over the years. The Equal Pay Act of 1963, Title IX, not IX, but Title IX of the Education Amendments Act of 1972, and also the Pregnancy Discrimination Act of 1978 helps guarantee greater gender equality. Speaking of the Equal Pay Act, this required equal pay, shocking, among genders for those performing the same jobs under equal conditions. Now, this basically had to do with federal jobs, so it didn't have a lot of impact on private jobs, but it was an early first step in the right direction. Title IX declared that no person on the basis of sex could be excluded from participation in any education programs or activities receiving federal financial aid. So if boys get a certain amount of spending of education money, females also get an equal amount of spending. So what this law did, by it requiring equal funding, it led to a dramatic increase in the number of females that were participating in high school and college sports. So basically now if there's a male sport, there generally has to be a female sport offered during that same season so that you can have equal opportunities. The Pregnancy Discrimination Act of 1978, this prohibits employers from discriminating against female workers who are or might intend to become pregnant, including in hiring, failure to promote, and in wrongful termination. This law at times can be difficult to enforce because if it has to do with hiring, a lot of people that aren't going to hire a woman because they're afraid she might get pregnant probably aren't going to write that down anywhere or tell anyone that. So in that sense, it can be hard to enforce. And also the Americans with Disabilities Act of 1990 prohibited against discrimination against people with disabilities, shocking, in various aspects of their everyday life, including employment, education, and also access to public accommodations. All right, this concludes Civil Rights, Section A, Equality Before the Law lecture. We hit Government Civic Standard 18, and objectively now you can examine how the 14th Amendment's Equal Protection Clause made possible civil rights reforms.